everyone, welcome to the Fine Line in Healthcare. I'm Lily. In this podcast, we talk about medicine, law, and ethics, how they overlap and interact with each other. We will explore the real life challenges and dilemmas faced by healthcare professionals, go through some medical dispute stories, and discuss how law and ethics are shaping medical practice in Malaysian healthcare system. In today's episode, we'll look at the legal side of medicine as we explore an ONG case law. By the end of this podcast, you will know what happened in the case, what impact it has on the medical fraternity, and what small steps we can take to create a safer and more supportive environment for practicing medicine. You might have heard that ONG cases have recorded the highest compensation awarded in medical negligence lawsuit in Malaysia. In fact, last September, just less than a year ago, the Court of Appeal ordered the government to pay 9.45 million ringgit in compensation to a 10-year-old boy who suffered irreversible brain damage during birth. The news was reported by the major media and it spread like wildfire among the doctors' groups. Other than holding the highest compensation record, did you know that obstetrics cases are also the leading cause of hospital admissions? In 2023, MLJU hospitals recorded approximately 2.6 million admissions. Pregnancy, childbirth, and the puerperium making up 19%, that is roughly 1/5 of total admissions. But whether this high admission rate actually correlates with the volume of complaints or medical negligence claims received in MLJU facilities, we are not entirely sure. For context, that same year, about 13,700 complaints were submitted through the CISPA system, with 1,700 classified as complex cases. Medical legal or potentially medical legal complaints typically fall within this complex category. The statistics I just mentioned can be found on the official MLJU website. It's pretty general data, but at least it's something open to anyone curious enough to take a look. Given this background, I have selected an ONG case for our first case law discussion here on this podcast. But don't worry, I'm not going to talk about those high-profile cases that you have probably read on social media. To set a positive tone, I've chosen a case with a favorable outcome for the medical side. In this case, the court dismissed the plaintiff's claims and the doctors involved were found not liable. Hopefully it gives a little sigh of relief for the medical community. I will begin with a brief summary of the background facts, followed by the key issues raised by the plaintiff and how the judge analyzed and ruled on them. I will also share my personal reflections on the judgment and offer some takeaways that may be useful for healthcare professionals. Are you ready? This case was heard in the High Court, with the judgment published in April 2024, just last year. The first plaintiff is a child diagnosed with cerebral palsy. The family sued several doctors from a government hospital, accusing them of medical negligence during the delivery. They claimed that the doctor's negligence caused cerebral hypoxia, leading to the child's condition. But after a full trial that lasted over 7 days, the judge dismissed the claim. What happened in this case was that the mother, who is also the third plaintiff, went to the hospital in October 2017 because of abdominal pain. The doctors diagnosed her as being in the early phase of labor and admitted her to the ward. While she was in the ward, a cardiotocography CTG recorded fetal bradycardia down to 60 beats per minute for about a minute, and then returned to a baseline of 140 beats per minute. The CTG was interpreted as suspicious by the attending doctor, and she was transferred to the labor room. In the labor room, she was found to be in the active phase of labor with cervical opening at 6 cm. The doctors noticed signs of fetal distress, so the on-call specialist decided to proceed with an emergency Caesar. It was classified as Category 2 urgency, meaning there was some risk to the mother or baby, but it wasn't an immediate life or death situation. During the surgery, the operating surgeon faced some difficulties because of fibroids in the lower uterine segment. The doctor needed to modify the incision. Eventually, the on-call specialist delivered the baby. The doctors also found the umbilical cord tightly wrapped around both of the baby's hips. From the moment they decided on the surgery to the time the baby was actually delivered, it took about 50 minutes. 50. The plaintiffs brought up several allegations. They say the doctors lacked skill and experience, didn't follow MOH guidelines, didn't get proper consent, didn't monitor the baby's heart rate closely enough, delayed the delivery, and made other technical errors. But after looking at all the evidence, the court decided that the plaintiffs couldn't prove the doctors had breached their duty of care. The way the umbilical cord was wrapped around the baby's hips was believed to have caused the hypoxia, which most likely occurred before the cesarean section was performed. So, the whole claim was dismissed. On top of that, the plaintiffs were ordered to pay 10,000 ringgit in legal costs. At this point, regardless of the outcome, it must have been a tough time for everyone involved: the patient, the parents, and also the doctors. What I want to talk about here is how clinical guidelines play a role in determining the standard of care in medical negligence cases. As a fundamental principle, a plaintiff must first establish that the doctor had owed a duty of care, then prove what the expected standard of care should be, and finally show that the doctor breached that standard and caused harm to the patient. In this case, both local and international guidelines were used to check if the delivery happened within the expected time frame and whether there was any delay. There are two key points from the judgment that I would like to highlight on this issue. First, should MOH guidelines be seen as the bare minimum that healthcare professionals must follow? Or are they more like a reference point for best or ideal practices? Second, how far can we apply the principle from rule against Ministry of Health to other cases, especially when assessing the standard of care based on the medical knowledge available at the time of the incident? During the trial, the defendant doctors referred to the guideline for caesarean birth issued by the UK's National Institute for Health and Care Excellence, the NICE guideline. According to this guideline, for Category 2 cases, a caesarean section should be done as soon as possible, ideally within 75 minutes of the decision. The doctors argued that in this case, the baby was delivered within 50 minutes, so they were well within the recommended time frame. On the other hand, the plaintiffs referred to the MOH operational policy for ONG services, which states that time for decision to caesarean is less than 30 minutes. The doctors countered that this policy refers to the time surgery should be initiated and not when it should be completed. What is really important here, and something policymakers worth noting, is how the judge addressed this issue. In paragraph 108 of the judgment, the judge stated that even if the MOH policy required that the delivery must be completed within 30 minutes from time of decision, it still doesn't set a mandatory minimum standard. The judge highlighted a key part of the policy's disclaimer, which basically acknowledged that not all MOH hospitals are the same. Some have different resources, staffing, and capabilities. So, a one-size-fits-all rule wouldn't be realistic. The following is the quote from the policy's disclaimer. The operating policies listed here are not the minimum standards that should be found in all hospitals and should not carry any adverse influence in any hospital that cannot comply with these policies. I searched for this policy and found the 2010 version available online. The 30-minute standard mentioned by the Plaintiff's Counsel appears on page 45 and 46 if you would also like to have a look. and the full disclaimer of the policy, which I believe is essential reading for policymakers and those who involved in guidelines drafting, is on page 8. The second key point regarding clinical guidelines is whether the principle from Roe against Ministry of Health applies to this case. The plaintiff's counsel argued that the NICE guideline should not be used as a reference because it was only published in 2021, while the incident happened back in 2017. In Roe against Ministry of Health, the court held that the standard of care should be based on the medical knowledge available at the time of the incident, not on newer standards that came later. The court basically said, you can't judge a doctor's actions using knowledge that didn't exist at the time. Fair enough, right? It wouldn't be reasonable to expect someone to follow rules that hadn't even been introduced yet. But here is the flip side, and this is where it gets interesting. While we shouldn't use newer, stricter standards to punish doctors for past actions, it also doesn't make sense to hold them to older rules if better, more flexible ones have already taken over. For example, if today's guideline allows up to 75 minutes for a C-section, is it really fair to say a doctor in 2017 had to stick to a 30-minute cutoff, even if there was a practice back then? The judge also brought up Section 57 Sub 2 of the Evidence Act 1950, which gives the court the green light to refer to reliable scientific documents when making decisions. So what does that mean for the medical community? Well, the principle still stands. You can't judge past medical decisions by today's tougher standards. But here is something worth thinking about. Medical guidelines don't always evolve to become stricter. In fact, sometimes they could potentially be relaxed because real-life experience shows the older standards were just too idealistic or hard to follow, especially in public hospitals where resources are limited and staff are stretched thin. That's why it's so important to keep policies and guidelines updated, not just to reflect textbook ideals or catch up with scientific development, but to make sure they are actually doable in the everyday reality of our local healthcare system. Now, when the public hear about the huge payouts in childbirth-related cases, it is easy to think that the court is coming down hard on the doctors, as if they are being punished. But that's not true. These big numbers aren't about punishment. They are mostly about covering the lifelong care and support a child might need because of the injury. Under tort law, compensation isn't meant to punish the wrongdoer. It's meant to try and put the injured party back in the position they would have been in if the negligence hadn't happened. And of course, anyone has the right to file a lawsuit if they believe there is a valid claim. In this case, the trial went on for 7 days, but in the end, the court dismissed the plaintiff's entire case. Not only that, they were also ordered to pay 10,000 ringgit in cost. This whole case left me with a few lingering questions. Did the plaintiffs, the parents, really accept the court's reasoning and decision in the end? Assuming they did, then I can't help but wonder what prevented them from reaching their understanding before going down the long, emotionally draining path of litigation. Was it lack of information? A breakdown in communication? Or just the feeling that legal action was their one and only option at that time? And that leads to something even bigger. Could this complaint have been handled differently? Could the complaint management within our healthcare system be further improved? And what about alternatives to court like bioethics mediation? Could mediation offer a more compassionate and constructive platform where families and healthcare providers came together not as enemies, but as people trying to understand what happened and why? Instead of confronting each other in court, maybe what we really need are more humane and honest conversations. Above are my reflections that came to mind after reading the judgment. This is not intended to serve as a full summary of the case. If you would like to explore the case in more detail, you may download the full grounds of judgment from the e-Kehakiman portal. We would love to hear your thoughts. Please feel free to leave a comment or share your feedback. If you find discussions like this helpful, don't forget to follow us for updates on future episodes. Thanks for tuning in. See you on our next episode.